Scores of asylum seekers are still in limbo tonight after the High Court reserved a decision on the legality of sending them to Malaysia. The case has been brought on behalf of a 16-year-old unaccompanied minor and a man in his 20s. At stake, the government's plans for offshore processing. Lawyers for the Commonwealth have argued there's no breach of Australia's international obligations, while those acting on behalf of the asylum seekers say the Immigration Minister has failed in his duty of care. Lateline's Hamish Fitzsimmons has been at the High Court in Canberra, and a warning: this report contains images of corporal punishment.
The two Afghan asylum seekers at the centre of this hearing won't know if they're being sent to Malaysia for another week. The fate of many more also hinges on the decision.
We've determined at this stage to act hard to break the people smugglers' business model. That's what the Malaysian arrangement is about. That is before the High Court at the moment, and of course there's a strict limit to what I can say about a court case that's in progress.
After a full day of argument before all 7 judges, the High Court has reserved its decision on whether removing asylum seekers to Malaysia compromises Australia's obligation under the International Convention on Refugees. Should the asylum seekers' lawyers succeed, experts say offshore processing will be scuttled.
Not only would offshore processing in Malaysia be impermissible under the Migration Act, but also offshore processing in Papua New Guinea are also Nauru.
The asylum seekers' advocates told the court Australia couldn't guarantee the safety of those sent to Malaysia under a deal which would see 800 asylum seekers exchanged for 4,000 people who've been processed as refugees. The Commonwealth Solicitor General argued the agreement and subsequent declaration of Malaysia as a suitable destination is legal and does meet the obligations of Australia under the UN Refugee Convention. But both sides agree on the significance of the case.
Our clients are asking the court to rule on whether what the government proposes to do is in fact lawful. That is, whether the Australian government's proposal to expel them to Malaysia instead of allowing them to stay in Australia and seek refugee protection here is in fact lawful and within power. So it's a fundamental issue to be resolved.
At the heart of this case is the question, does removing asylum seekers to a country like Malaysia breach Australia's commitment to legally binding international human rights conventions? Lawyers for the Commonwealth say when deciding to send people to Malaysia, the Minister asked all the right questions regarding human rights. Lawyers for the plaintiffs say that's not the case. Also at issue is the question of unaccompanied minors.
The second major argument is that because of the Minister's obligations under the Guardianship Act, he doesn't have a capacity to relocate minors offshore for processing. So it goes to his obligations as the legal guardian of those unaccompanied minors who are arriving in Australia as non-citizens.
The Commonwealth is arguing that Australia's only obligation is to ensure those with a well-founded fear of persecution are protected. But the asylum seekers' lawyers say the 16-year-old in the case is a Shia Muslim and would be persecuted in Malaysia, which has a Sunni majority. They also told the court more than 29,000 foreigners have been caned in Malaysia between 2005 and 2010.
They're petrified. They're very anxious, they're petrified. I've spoken with them and they're awaiting the outcome of this situation where they have very substantial fears about being expelled to Malaysia.
The High Court will deliver what could be a political hand grenade next Wednesday afternoon. Hamish Fitzsimmons, Lateline.